Mr. Weldon?
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor. And of course, as this Court is aware, presiding over the trial, I'm not going to go into great detail about the facts of the case. I think Your Honor is very well aware of the facts. I would just point out one last time that we know from the evidence, Your Honor, that these propofol shipments began in April of 2009, and that this behavior, this careless and reckless behavior on the part of Dr. Murray was continuing for at least 2 months before Michael Jackson died at the hands of Dr. Murray. On June 25, 2009, we know that Conrad Murray administered propofol once again, as he had done the prior 2 months. We know that during that time, when Michael Jackson was sedated, heavily sedated, under propofol and other benzodiazepines, that he was left alone and abandoned by the person he entrusted his life with, Dr. Murray. And we know that Michael Jackson, as a direct result of the actions of Dr. Murray, died on June 25, 2009, leaving his 3 children without their father. We also know, Your Honor, about his post-crime behavior, the cleaning up of the crime scene, lying to the paramedics, lying to UCLA, being deceptive with LAPD in their interview, and later explaining that deception in his documentary, as it was referenced, by saying, well, they never asked me about the phone calls, so I never told them. I didn't think it was important, so I didn't tell them, and things of that nature. But we know that on June 25th, Dr. Murray, at the hands of Dr. Murray, Michael Jackson died, and we know that the criminal behavior on the part of Conrad Murray, where he looked out for himself and not Michael Jackson, he looked out for himself and not the family of Michael Jackson, continued past Michael Jackson's death. We know it continued at UCLA when Conrad Murray says in his interview statement that he told Mrs. Jackson, who was heartbroken, that he didn't know what had happened. We now know from Mrs. Jackson's interview with the probation department, according to Mrs. Jackson, he never told her anything at all. In fact, he never even consoled her at UCLA. And Mrs. Jackson herself characterizes those statements by Conrad Murray as lies. That is simply the bare facts that this Court knows as to what happened both before, during, and after Michael Jackson's death. As it relates to the specifics of sentencing, Your Honor, defense counsel has cited a number of arguments where they advocate probation, and they cite California Rules of Court 4.414. And I want to talk about a couple of the factors actually cited by the defense that I think essentially mandate a denial of probation in this case. First, the nature, seriousness, and circumstances of the crime. And in that regard, Your Honor, I would cite Your Honor from the date of the verdict, when Your Honor stated, quote, Dr. Murray has been convicted of a crime involving homicide. This is not a crime involving mistake of judgment. This is not a crime involving administration of drugs per se. This is a crime where the end result was the death of a human being. And I think that eloquently sums up the nature, seriousness, and circumstances of the crime. The other factor cited by defense counsel in requesting a grant of probation is that the factor regarding the vulnerability of the victim. And I would submit to this Court that not only was Michael Jackson extremely vulnerable at the time of his death, when one has to know that he expected Conrad Murray to be by his side monitoring him, but more so the fact that that very vulnerability was created by Dr. Murray. The vulnerability was exacerbated by the actions of Dr. Murray, who had submitted him to this pharmaceutical experiment for the prior 2 months. Michael Jackson was extremely vulnerable and literally had entrusted his life in the hands of Dr. Murray. That would be a factor advocating against a grant of probation. The infliction of physical injury. Obviously, the death of Mr. Jackson at the hands of Conrad Murray through his gross and criminal negligence advocates against a grant of probation. the fact that the defendant was an active participant. And I think this is best summarized by the very simple fact that that propofol was in the home because of Conrad Murray. The lack of monitoring equipment, the very lack of that equipment was because of Conrad Murray. And the abandonment of Michael Jackson was at the direct hands of Conrad Murray. So the active participation of the defendant is beyond question, and that advocates against probation, Your Honor. The planning and sophistication of the crime, and although the people clearly acknowledged that this is not an intentional act in the specific intent crime, but a crime of gross negligence, I think there's clear evidence of the planning and sophistication that went into this. The fact that the pharmacist in Las Vegas was told there was a clinic in California to which he should ship the propofol. The fact that the defendant clearly and intentionally did not maintain medical records, although we know from the evidence he had routinely kept medical records in the past involving the very care of Michael Jackson. When it came to the treatment of Michael Jackson with propofol, the defendant made a clear, conscious decision not to keep medical records. It was that planning and sophistication because he knew what he was doing was wrong. He knew it could risk the life of Michael Jackson, and he made a decision not to document that behavior in any written manner. Again, lastly, the position of trust, Your Honor, as it relates to whether the court should grant probation. The court, the people, the jurors, everyone heard a great deal about the special relationship between a doctor and a patient. That fundamental trust that must exist for a healthy, competent relationship to exist between a doctor and a patient. That relationship was grossly corrupted by the actions of Dr. Murray. That relationship was destroyed. That doctor-patient relationship was fundamentally destroyed by Dr. Murray in his treatment of Michael Jackson. Michael Jackson was in a position of trust where he trusted he would be monitored, where he trusted he would be cared for by Conrad Murray so that he would see another day and that he would see his children another day. So I think the factors under California Rules of Court 4.414 argue strongly against any grant of probation in this case. It is the people's position that prison is warranted. And I would highlight specifically factors in aggravation that warrant a state prison sentence of 4 years, Your Honor. And before going into the factors, I would just simply state that this crime occurred on June 25, 2009. But as far as looking at factors in aggravation, we know the defendant was playing Russian roulette with Michael Jackson's life every single night. Every single night that they were up in that bedroom and Conrad Murray was administering propofol in that reckless, obscene manner, Michael Jackson's life was put at risk. So the crime, when looking at it and looking at whether it's an aggravated crime or not, I think one needs to look at the full picture and all the evidence that was presented before this court and before this jury. The actions leading up to the crime. Again, the propofol shipments. Conrad Murray makes statements where he walked into the situation and then later learned that Michael Jackson had a dependency in propofol. But we know from the propofol shipments that these began immediately upon Conrad Murray agreeing to participate as Michael Jackson's doctor. These began in April 2009, April 6, 2009 to be precise, with the first large-scale propofol shipment to one of Conrad Murray's girlfriend's apartments. When dealing specifically then with the factors in aggravation, I would ask the court to consider that pre-crime behavior, the criminal behavior of June 25, 2009, and then the post-crime behavior, Your Honor. At the point when Conrad Murray knew he had erred, at the point when Dr. Murray knew his actions had caused the death of Michael Jackson, he didn't, as one would hope a doctor would do, immediately begin to cure the situation, to offer help or guidance. He started looking out for himself. He started cleaning up the room. As the court is well aware, he waited 20 minutes to have anyone call 911. He then lied repeatedly, even to the point If you believe he made the statement to Catherine Jackson, although again in the probation officer's report she said no such statement was ever made, and that in fact is a lie, even to the point at UCLA when he lied to the family, when they're yearning for answers about what happened to their loved one, when they're looking to this individual who represents himself as Michael Jackson's doctor, and he will not even give them the answers they deserve. As the court knows, it is not until 2 days later that the defendant comes forward with any information about the propofol. When Michael Jackson is long since dead, when the family has been left wondering what happened to their loved one, 2 days later is when he first comes forward with any statements regarding the propofol. So I think in looking at the picture and the totality of the crime, Your Honor, one must look to the behavior before the death of Michael Jackson, the behavior at the time of Michael Jackson's death, notably, again, while Michael Jackson is either dead or lay dying, Dr. Murray is on the phone talking to his girlfriend. That is important because it highlights the priorities that Dr. Murray had when he should have been solely focused on his patient, on Mr. Jackson, when he should have had no other concern but his patient who was put under via propofol. For some reason unknown to anyone but the defendant himself, the defendant thought it would be important to call a girlfriend in Houston, Texas. That highlights dramatically where the defendant's priorities were, where his concerns were, and where his lack of concerns were, namely for the health and livelihood of Mr. Jackson. So looking at the factors in aggravation under Rules of Court 4.421, Your Honor, I would highlight 4 specific factors. 1, that the crime involved a threat of great bodily harm, disclosing a high degree of callousness. And I think that's abundantly clear from the evidence in this case. The repeated administration of propofol without the necessary monitoring equipment or personnel. And again, going back to what I just mentioned about the priorities at the very moment preceding the discovery of Michael Jackson laying in bed, that Dr. Murray, instead of being focused on Michael Jackson, was instead focused on social calls to people unrelated to the care of Michael Jackson. And Michael Jackson was, in every sense of the word, at that time and previous to that time, abandoned by Conrad Murray. The second factor in aggravation, again, I touched on when arguing against probation, and that is the vulnerability of the victim. And just briefly, Your Honor, I would just reiterate that it wasn't just the vulnerability of Michael Jackson at that moment, being under the influence of the various drugs that the defendant had administered, but the fact that that vulnerability at the minimum was exacerbated over 2 months' time by the actions of defendant Murray. In essence, Dr. Murray created this vulnerable situation. And when Michael Jackson was at his most vulnerable, Dr. Murray left him alone to die. The planning and sophistication and professionalism as a factor in aggravation I already touched on, Your Honor. The deception, the efforts at concealment, both before the crime, having the propofol shipped and just left at a doorstep, apparently, of his girlfriend's apartment. The concealment following the immediate death of Michael Jackson, the lies, the cover-up, the lack of medical records. This all indicates that Conrad Murray, in his mind, knew perfectly well that what he was doing was wrong, and he knew perfectly well that what he was doing was risking Michael Jackson's life, and he did not want to maintain a record of that behavior. And again, the taking advantage of the position of trust could not be more clearly demonstrated than in this situation where you have a patient and a doctor, the patient who, according to Nurse Lee, had indicated, "I'll be safe as long as I'm monitored. As long as I'm monitored, I'll be safe." Michael Jackson obviously believed that. He acted in conformity with that. And when he was put under with propofol by Dr. Murray left him alone, where he died in his own bed. It is the people's position that these factors in aggravation warrant a state prison sentence of 4 years, Your Honor. Again, because it is not simply the act that occurred at around noon on June 25th, 2009, but it is all the acts of the defendant, all of the deception, all of the lies, the cover-up, as well as the extreme nature of the negligence in this case and the repeated negligence in this case exhibited both before the crime, during the crime, and after the crime. It is those actions that warrant a state prison sentence of 4 years. I would also ask the court, in making a determination as to sentence, to consider the appropriate restitution. And the people have submitted to the court from the estate of Michael Jackson figures that were obtained. And specifically, we had requested, as 1202.4F allows for, monetary amounts for the burial and funeral expenses, as well as monetary amounts for lost wages and earnings. And the numbers provided by the estate are enormous. And that is a unique situation to this case, Your Honor, where Michael Jackson was set to take on one of the biggest tours of his career, where his personal earnings alone were calculated to be $100 million. $100 million that Michael Jackson would have earned and that would have benefited his children who are victims under the law. That is not a fictional amount. That is an amount given from the estate of Michael Jackson by the attorney, Mr. Howard Weitzman, and he estimates that that is an accurate figure of what Michael Jackson's own personal earnings would be. The people are under no illusion that Dr. Murray has the ability to pay $100 million, but the victims are entitled to their restitution under the law, and the people have an obligation to seek out those restitution amounts and bring them to the attention of the court. And that amount for the lost wages and earnings for that tour was $100 million. A time frame that's actually quite conservative. It was only about 10 or 11 months in which that money would have been earned. From there, the tour may have gone longer, films may have been made, future earnings may have been forthcoming. But the people chose in this calculation to consider just the tour, the 50 shows that we know for a fact were sold out, tickets purchased, and Michael Jackson's expected personal earnings to be $100 million. We also included the amount of the $1.8 million for the funeral, memorial service, and burial. And again, that's provided by the estate of Michael Jackson. It's included in the people's sentencing memorandum as part of Exhibit B, Your Honor. And we'd ask the court to consider those monetary amounts in fashioning what the court considers to be a fair and just and appropriate restitution order for the benefit of the victim, namely Michael Jackson's 3 minor children. We additionally add in there the requirements for the attorney's fees and the interest fees and other mandated areas of the law. Finally, Your Honor, I'd ask that the court, in fashioning what the court considers an appropriate sentence, and again the people's request being 4 years state prison, as well as all the appropriate fines and the restitution order to the victims, I'd ask the court to look again at the full picture of this case. The events preceding the crime, the events of June 25th, and the events after the crime. Because this was not one solitary mistake of judgment or one solitary lack of attention. This was a consistent pattern of behavior exhibited by Conrad Murray, whereby he hoped for payment of $150,000 a month, and in exchange he would provide propofol to Michael Jackson on a nearly nightly basis. I would also ask the court to consider the defendant's lack of remorse and lack of personal responsibility. And in considering that, I would ask the court not to look so much at the words put in the defense sentencing memorandum, but the defendant's own words from the documentary that he or his defense team or whoever produced. His own words when he was interviewed in that documentary, reportedly 9 days before verdict in this case, when everyone is pursuing the case, the jury's doing their job, witnesses are testifying, and what we learn is 9 days before the verdict, Conrad Murray is asked essentially if he bears any responsibility or feels any guilt for what he has done. And his exact words from his mouth on videotape that he chose to produce were, quote, I don't feel guilty because I did not do anything wrong. Those are the defendant's videotaped, audiotaped words, again, reportedly 9 days before the verdict. He chose, as was his right, not to testify, but he also chose to make this statement about his sense of responsibility. And what he told everyone who saw that documentary is that he does not feel guilty because he did not do anything wrong. Even at that point, weeks into the trial, years into the filing of the case, Dr. Murray indicated for all to see he did nothing wrong. And I'd ask the court to consider that in determining what appropriate prison sentence to impose. I would also ask the court to consider the statements of Michael Jackson's mother that are contained in the probation officer's report. As the court knows, she was interviewed by the probation officer for a victim statement, and she related, and I'll just highlight some of what she related to the probation officer, Your Honor, as it's relevant to the sentencing. Mrs. Jackson related that all of the family members feel angry and betrayed by the defendant, that not a day goes by when she does not think about her son, that all of her children and all of her son's children think about Michael daily. She noted that every morning he is the first thing she thinks about. Michael Jackson was his children's world, and their world collapsed when he left. While at the hospital on the day of the incident, after Mr. Jackson was pronounced dead, his daughter Paris was crying and stated, "I want to go with you," referring to her dad. Mrs. Jackson relays how Mr. Jackson and his children were making plans to enter the filmmaking industry and to pursue that together as a family project. Mrs. Jackson relays how she was personally offended, as was the rest of the family, when on the one-year anniversary of Michael Jackson's death, Dr. Murray arranged for a camera crew or photographer to accompany him to Michael Jackson's cemetery to be photographed. Mrs. Jackson indicates that the defendant violated her son's trust, failed her son, and failed her family. And Mrs. Jackson asks that the defendant receive the maximum sentence allowed under the law. Your Honor, the people join Mrs. Jackson in asking for the maximum sentence. This case, based on the defendant's own behavior, the defendant's own statements, warrants the maximum sentence. That sentence being 4 years in state prison. That is the just sentence, and that is the sentence we ask this court to impose, along with the requested restitution as the court deems appropriate. Thank you, Your Honor.
Mr. Walgren, thank you. The people had asked repeatedly for a maximum sentence of 4 years in state prison. Pursuant to the provisions of Penal Code Section 1170, Subdivision H, the Realignment Act, does the court have the authority under that provision of state law actually to send Dr. Murray to state prison, if I accept your argument?
He would not be housed in state prison.
Why is that?
Because of the very law the court's cited, because of the new statute. He would be housed either locally in a county jail or by other means that the sheriff deemed appropriate.
Does the court have any discretion in that sense?
No, Your Honor.
Mr. Walgren, you have submitted an Exhibit B, which is a letter from Mr. Howard Weitzman on behalf of the estate, wherein Mr. Weitzman lists certain expenses as memorial service, funeral, and associated expenditures in the approximate amount of $1,821,871.65. Is there any itemization of those expenses?
Not at this time, Your Honor, and it's a very reasonable and fair question. I will explain to Your Honor that obviously these finances are an extremely complicated manner due to the date for sentencing that was set. The people diligently and immediately began getting into contact with the appropriate representatives to obtain the appropriate restitution amounts. The court had asked for those amounts, as is appropriate, and these are the amounts represented by the officer of the court, by the estate, by Howard Weitzman, that he represents are accurate for both the funeral and burial expenses as well as the tour. At this time, today, I do not have an itemization to give to the court.
Mr. Weitzman also indicates that the above information is a combination of monies actually spent and some very sophisticated projections on the anticipated revenue stream from a concert tour that had been sold out before Mr. Jackson's death. And the amount listed is the sum of $100 million in revenue. Would you believe that the court and the defense in this case are entitled to an itemization of the proposed sophisticated, anticipated revenue stream?
Yes, Your Honor.
Thank you. And let the record reflect that I have received, reviewed, and considered the people's submission in terms of the sentencing memorandum, as well as the exhibits attached there to Exhibit A, which is a CD, DVD, and Exhibit B, which is a letter from Mr. Weitzman. I have received, reviewed, and considered the defense sentencing memorandum, including the attachments thereto, a significant number of reference and character letters by friends and family and associates of Dr. Murray, and also I have received, reviewed, and considered the formal probation report in this case.